It's Nolan.
Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. Hey, we ain't got a lot of time left. If the rap game fall, bet I did this shit to death. No motivation to stretch it. Focused on ethics. Try to survive in my section. Shit is depressing. Used to care about niggas. Now I give a fuck about your whereabouts. Publishing, I'm clearing house, nigga. Music on shows, I'm on Paramount, nigga. Killing every rapper breathing, and I'm bailing out quicker, single handed. Never panic, I get disbanded. Reprimanded, ass handed, then they vanish. Hip hop, nigga, I perfected every element with 4-finger rings on. Call me Captain Planet. Street shit done. These niggas scum, I don't appreciate none. Nigga thinking nigga stunt. Came from a village, bumping dealer in the slum, moving on another pillar. I'm the realest that they come. I don't need no squad. My rap clean like Pino on the beats like Ringo Starr. Blast on niggas like Beano bars, doing numbers in the bank like bingo cards. My respect level lower, next level flow us in the text. Bitch, your ex come and blow us. Old school niggas still dressed in below us in the jet, watching Plex while I flex on them niggas that's below us. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this Monday afternoon. In this video, we're going to be picking up where we left off with the Megan Thee Stallion versus Milagro case. All right. Now, the last time I got on here and talked to y'all, there were some hearings to be had. There was supposed to be some conversations with Aiden Ross. I believe there was some conversations to be had with the DJ that don't spin. We also have Tory Lanez, who was trying to duck off from being redepositioned. And these are all depositions that I'm talking about between Aiden, No Spin, and the rapper whose hair don't grow. Um, all of them have been ducking off, trying to avoid depositions or redepositions. All of those motions have been declined. Just a few days ago, there were some pre-trial hearings and stuff like that. I don't have the transcript. Document Tings has read those transcripts on his YouTube page, and it's a lot. 57 pages, 90 something pages. I don't wish to sit here and go through every word of that. But on the heels of those conversations, it seems that there is a dispute over the defamation claim filed by Megan Thee Stallion. Defamation per se, more accurately, okay? Now, Milagro's legal team is trying to push back on defamation. They don't believe that she, up to this point, has proven defamation, or so it sounds like they're trying to get that taken out. So both parties, Megan and Milagro, their legal teams have submitted paperwork on why or why not they think that defamation per se should be permitted to move forward into the trial. Okay, I'm going to get into those documents. Milagro and her legal team have also filed a motion to continue, which is to actually push back. Of course, trial starts on November 17th. They issued a motion to try to get it pushed back to November 18th for an additional day. It was denied, but we're going to go through that as well. And outside of this case, I'm also going to get into some of the conversation that's been going on as the NBA season has started. Klay Thompson for the Dallas Mavericks is having a little bit of a rough patch starting the season, and because his shots are not sinking, people are now trying to blame Megan Thee Stallion as the reason why he's not playing well. I find that to be very suspicious. Klay Thompson really has not been playing well since he left Golden State, and he wasn't doing all that great his last year at Golden State. But of course, people who ain't really locked in with the information, they're using this as a way to try to say that she's messing up his life, or she's reflecting a negative cast over how he plays. I don't see how that has any correlation, but we're going to get to it because clearly this is something that people are trying to run with. So we'll address that in a few. But first, let's get into this whole Megan v. Milagro thing. And first piece of paperwork I want to get into is Megan's memorandum of law as to why she believes that defamation per se is permissible and is par for the course in this lawsuit. Okay, so once again, we have Megan's memorandum of law regarding defamation per se. Pursuant to the court's request on October 30th, 2025, plaintiff Megan Pete, by and through her undersigned counsel, hereby submits the following memorandum of law regarding defamation per se. Under Florida law, a public figure may maintain a cause of action or for defamation per se without proving actual financial loss. Florida courts have consistently recognized that when statements are defamatory per se, such as those imputing criminal conduct, professional incompetence, or moral turpitude, the law presumes general damages, including harm to reputation, mental anguish, and humiliation. Okay? Explaining that in cases of defamation per se, liability itself creates a conclusive legal presumption of loss or damage and is alone sufficient for the jury to consider punitive damages. All right. Now, let's just go back up here. Imputing criminal conduct, professional incompetence, or moral turpitude. These are all things that actually fall under Milagro's commentary. Number one, imputing criminal conduct. She tried to say that Megan Thee Stallion literally lied on the stand in front of the judge and jury in a courtroom where, of course, if you're found lying, then you would be perjuring yourself, right? Professional incompetence. Milagro has come out many of times and questioned Megan Thee Stallion's aptitude. She at one point suggested that Megan Thee Stallion needs a handler and is not cognizant of what she's doing. She tried to say that she was mentally retarded, a word that I refuse to use on my channel, but you know the word. She literally said it. Right? She says that T. Ferris is her handler, not her manager. She also alleged that Megan Thee Stallion and T. Ferris were in a romantic relationship and that Megan's mother, Miss Holly, was also in a romantic relationship with T. Ferris, which is why in Bigfoot, you got some of the lyrics that you got on there. And of course, as it pertains to moral turpitude, I would think that's speaking to somebody's moral principles, their moral code, basically saying that they are morally corrupt. Okay? So I just want to kind of expound on that piece real quick. The rule distinguishes between per se and per quote defamation. In per quote defamation actions, plaintiffs must plead and prove special damages. In per se actions, no such showing is required because the nature of the defamatory statement is inherently injurious. Federal and state courts applying Florida law have repeatedly allowed public figures to proceed on claims of defamation per se without requiring proof of economic harm. Okay, so they get into some examples here. We'll go past that. Plaintiff has identified no authority in Florida or the 11th Circuit holding to the contrary. Okay, and they get into some public figure stuff up here, but again, I'm just trying to get through them. Well, shit, why not just read it, right? Denying motion to dismiss defamation per se claims asserted by famous rap artist. So that was a rapper in this one. This one, WPB Residents for Integrity and Government, Inc. versus Material. This is 2019, affirming denial of motion to dismiss and for summary judgment of 2 defamation per se claims asserted by public figure. During the October 30th, 2025 pretrial conference, defendant submitted authority, Mastandrea v. Snow, to plaintiff's counsel purporting to prove the contrary. It does not. Mastandrea did not address or even mention the concept of defamation per se, nor did it hold that a public figure must prove actual loss to recover for reputational harm. Instead, the decision turned solely on the absence of actual malice, which is a distinct constitutional requirement for public figure and non-public figure plaintiffs alike, and the first DCA expressly declined to examine the other elements necessary to sustain the trial court's determination that the anti-SLAPP statute applied. Accordingly, Mastandrea offers no support for the proposition that public figures must prove pecuniary loss in per se cases, or that a public figure is barred from asserting a defamation per se claim in the first instance, as defendant asserts. Florida precedent makes clear that once a public figure demonstrates actual malice, the traditional presumption of damages in per se defamation remains intact. Okay? So this is Megan's memorandum of law as to why defamation per se should stand. Now, as it pertains to financial losses, Megan has also indicated numerous financial losses, numerous deals, numerous endorsements that were lost over the last couple of years. So I don't think it would be hard for her to prove financial damages or losses. But at this point, this is what they brought to the table. They want this to stand. You know, they don't want to have to just keep maneuvering, but I'm sure if needed, they will. But we'll just have to see how the judge determines, right? And next, we're going to get into Milagro, why her and her legal team are trying to get defamation per se knocked off. But before we get there, here's a quick little message. There's a reason rappers can turn any story into a hit track. Just like there's a reason Morgan & Morgan is America's largest injury law firm with over 1,000 attorneys and more than 100 offices nationwide. If you've been seriously injured in an accident, your case could be worth millions. But the truth is, a lot of people either don't file at all or get taken advantage of by insurance companies. When you hire Morgan & Morgan, it's like hiring a legal army that has your back. If you're injured because of someone else's negligence, you deserve to be paid. No shortcuts, no lowball offers. In fact, they've secured some major verdicts in the past. For example, in Florida, they got a victim who was in a life-altering car crash, $12 million. 34 times the highest insurance offer. They got another victim in Philadelphia, $26 million. 40 times the highest insurance offer. Not all law firms are created equal. Morgan & Morgan is the biggest for a reason. They will fight for the biggest award possible and have won a lot. So if you're ever injured, you can check out Morgan & Morgan. Their fee is free unless you win. That's right, no upfront costs. They only get paid if you get paid. You can start your claim now by clicking the link in the description or by scanning the QR code on screen from your phone's camera. Again, if you find yourself injured, you can check out Morgan & Morgan. Don't say I never told you nothing, man. All right, so now we're getting to Milagro's memorandum of law in opposition to plaintiff's memorandum on defamation per se, right? So now this is her counter. So defendant Milagro Elizabeth Cooper, by and through her undersigned counsel, respectfully submits this memorandum of law in opposition to plaintiff Megan Pete's memorandum regarding defamation per se. The defendant shall address 2 points of law in this brief. 1, the standard of proof is of actual malice, for public figure plaintiffs, New York Times Co. v. Sullivan. And 2, there is no presumption of actual damages against media defendants under both new and old law. Okay? So this is their 2 grounds that they're publishing this on. The standard of proof is actual malice for public figures, and they claim there is no presumption of actual damages against media defendants. I'm guessing they're trying to say the media is protected from actual damages. Interesting. I don't know how that's going to hold up, but we'll continue. Defendant has read the cases plaintiff has cited, which mention, but are not on point of the issues discussed above. The cases concern partial granting of interim orders, dismissal of issues at summary stages, and concern issues such as limitation. The recent case relied upon by defendants, Block v. Matesic et al., discussing the standard of defamation per se, states the standard for actual malice dismisses the claim for lack of showing of actual malice and seldom discusses measure of damages in defamation per se, but discusses instead defamation per quote. It is also to be noted that there were multiple defendants in the case and is silent on whether the presumption of damages under defamation per se applies to a public official or public figure. Recent cases cited by plaintiff below: C. Barisha v. Lawson and Reed v. Chambly, among others, demonstrate that a public figure must demonstrate actual malice to proceed in a claim. Plaintiff's argument that economic loss does not need to be proved to proceed in a claim, even if accepted, is a confusing way of stating the law. As to proceed, actual malice first needs to be shown and liability established. The economic element of presumption of damages shall become an issue after proving actual malice, for which see point 2, no presumption of damages against media defendants. I'm gonna continue because y'all I don't know. They look a little flimsy to me, man. They look a little flimsy. Cause actual malice has already been upheld in the complaint. But whatever. The controlling legal standard for public figures requires proof of actual malice. Plaintiff is indubitably a public figure, and therefore her defamation claim is governed by the constitutional actual malice standard. The U.S. Supreme Court in New York Times Co. v. Sullivan held that a public figure may not recover for defamation unless she proves by clear and convincing evidence that the defendant published the challenged statement with knowledge that it was false or with reckless disregard for whether it was false or not. Yeah, this ain't gonna hold up too strong, my boy, or my girl, or whatever you is. I'm talking about the lawyer, not Milagro. I know she's a woman. That thing hanging on by a thread, man. But do what you gotta do. Do what you gotta do. Try to protect your client. The court extended this rule to all public figures in Curtis Publishing Co. v. Butts 388. Florida law adopts this standard unequivocally. In Jews for Jesus Inc. v. Rap, the Florida Supreme Court held that public officials, all-purpose public figures, and limited-purpose public figures must prove that the defendant acted with actual malice. Okay. Likewise, Smith v. Cuban American National Foundation reiterates that actual malice is required regardless of whether the alleged libel is actionable per se or per quote. This controlling authority forecloses any attempt by plaintiff to avoid the constitutional fault requirement by characterizing her claims as per se. It's already been determined that Milagro made reckless statements knowingly that they were false. They even addressed that in her in her deposition, which she acknowledged. But we shall continue. In Reed v. Chambly, the court affirmed dismissal of defamation and defamation per se claims brought by a public figure plaintiff against media defendants because the complaint did not adequately plead actual malice. The court expressly held that for claims against a public figure for defamation, defamation per se, or defamation by implication, a plaintiff must plausibly allege that the defendant acted with actual malice, and conclusory allegations are insufficient. Similarly, the 11th Circuit in Turner v. Wells explained that allegations of animus, hostility, or ill will cannot substitute for actual malice because actual malice is a subjective awareness of probable falsity, not personal dislike. Milagro sat in the courtroom and saw exactly what happened, saw exactly how things played out, and she came out and purposely tried to mislead the public on what took place in the courtroom. So yes, awareness of probable falsity. Hey, but I'm not a judge and I'm not a legal professional. All right. I'll leave that to the ones who do this. Further, the Florida First District Court of Appeal reaffirmed this requirement in Mastandria v. Snow, where the court held that summary judgment was appropriate because the plaintiff, a public figure, failed to present evidence of actual malice. The court expressly declined to reach the remaining elements of the claim because the absence of actual malice was dispositive. This principle is also reflected in C. Barisha v. Lawson, which held that even where defamatory meaning could be inferred, a public figure plaintiff fails as a matter of law without evidence that the defendant entertained serious doubts about truthfulness. In sum, the actual malice standard is a constitutional threshold that applies before any discussion of damages or classification as per se or per quote arises. Because plaintiff does not and cannot establish actual malice, you sure about that? Her defamation per se theory cannot proceed as a matter of law. 2, Florida no longer recognizes presumed damages for defamation per se in actions against media defendants. Plaintiff's memorandum rests on the premise that because she labels her claim defamation per se, the law automatically presumes general damages such as reputational harm, humiliation, and emotional distress. That's not what's in the actual complaint. It's not a presumption at all, but we'll continue. However, presumed damages in defamation per se cases was expressly curtailed by the Florida Supreme Court in Mid-Florida Television Co. v. Boyles. So, which held that Florida no longer recognizes presumed damages for defamation per se in lawsuits against media defendants. Okay, this part is going to be interesting, saying that you no longer presume damages for defamation per se against media. Plaintiff Megan Pete is a public figure. Her career, her sexually explicit lyrics, and her very public persona place her at the forefront of public discourse. Not y'all throwing sexually explicit lyrics in here. The statements at issue concerning her conduct in a highly publicized legal case and her personal relationships are unquestionably matters of public concern. I think y'all might regret putting that in there, but that's just my opinion. For the purposes of this motion and consistent with First Amendment principles, the defendant, as a blogger and commentator on matters of public interest, functions as a member of the media, quote unquote. The protections established in Boyles are functional, not institutional, and apply to those who engage in public commentary on newsworthy events. And I also could have swore that the judge said that she wasn't considered a media personality or whatever, news, but since I can't think of the exact quote off top, I won't push it. In Boyles, the court rejected the common law rule that presumed damages flow automatically from defamatory statements categorized as defamatory per se. The court held instead that the First Amendment requires courts to scrutinize damages in defamation cases involving matters of public concern and statements disseminated by media defendants. Specifically, the court explained that the common law rule permitting recovery of presumed damages in libel actions is incompatible with First Amendment protections, where the defamatory statements involve matters of public concern and the defendant is a media publisher. Thus, after Boyles, Florida no longer recognizes presumed damages in defamation per se claims against media defendants unless the plaintiff first proves actual malice. All right? So that's what's going to be the determining factor, is Megan and her legal team really honing in on actual malice, which I believe they've already exposed in the litigation up to this point, but perhaps they're going to have to make it more abundantly clear so that the judge will allow it to move forward, okay? And even where actual malice is shown, Florida courts require competent evidence of resulting injury. Damages are not presumed by virtue of the per se label. Florida courts and federal courts applying Florida law continue to cite Boyles as good law. Public figure plaintiff must plead and prove actual malice and may not rely on conclusory allegations of harm. None of the decisions in plaintiff's memorandum override Boyles. None are issued by the Florida Supreme Court, and none establish that a public figure may recover presumed damages in a defamation per se action without meeting the First Amendment's actual malice requirement. In fact, several of these cases simply address pleading sufficiency at the motion to dismiss stage, not entitlement to damages at trial. Okay, that's an interesting piece to point out. Moreover, Block v. Matisic involved multiple defendants in allegations of coordinated publication, making it factually an opposite to the present action, where plaintiff alleges statements by a single defendant. The only Florida authority capable of controlling the question of presumed damages in defamation per se cases is the Florida Supreme Court, and that authority holds against plaintiff's position. Neither Lawnwood Medical Center v. Sado, nor Materio, nor the federal cases cited by plaintiff overrule or limit Boyles. Lawnwood itself acknowledges it is applying the traditional per se framework outside the media defendant and public figure context. Here, however, plaintiff is both a public figure and the challenge statements were made by the defendant in the media public discourse context, placing this case squarely within the constitutional constraints articulated in Boyles and Sullivan. As per Elrich, J. and Boyles, to avoid confusion, an attorney should avoid the use of the term per se and instead spell out that defamation is clear on its face if circumstances so dictate. Accordingly, plaintiff may not rely on any presumption of damages and must instead present competent proof of actual injury after first establishing actual malice by clear and convincing evidence. Plaintiff's memorandum, which proceeds as though presumed damages simply attach automatically, therefore does not address the gap in the governing law and does not entitle plaintiff to damages where plaintiff is a public figure and the defendant is a media defendant. For these reasons, defendant respectfully requests that this court, 1, acknowledge that Mid-Florida Television Code v. Boyles remains controlling law and prohibits the presumption of damages in this case. 2, hold that plaintiff as a public figure must prove actual malice and actual damages through competent evidence at trial. And 3, reject plaintiff's request for a defamation per se jury instruction that would improperly suggest damages may be presumed and instead instruct the jury that plaintiff bears the burden of proving every element of her defamation claim, including actual harm to her reputation. Okay, they trying to fight. Can't be mad. That's what they're getting paid to do. They trying to fight. They trying to find their legal, their legal reasonings as to what could protect Milagro. Will it work? I can't say. But in my personal opinion, it seems flimsy. Also uploaded into the docket, this is coming from yesterday, we have plaintiff, and of course plaintiff is Megan Thee Stallion, with her proposed voir dire questions. Okay? So these are questions that will be presented to the jury. Plaintiff Megan Pete, by and through undersigned counsel and pursuant to the court's order providing instructions for jury trial, respectfully submits the following proposed questions for voir dire and questions that, to the extent possible, they be included on the written questionnaire provided to jurors. You could say voir dire if you want. If you want to be, W.E.B. Du Bois about it. Have you heard of plaintiff Megan Pete, professionally known as Megan Thee Stallion, before today? If so, do you have any opinions, positive or negative, about her as a person or as an entertainer? 2, have you heard of defendant Milagro Cooper, also known by her internet handles as Milagro Grrrls or Mob's World, before today? If so, do you have any opinions, positive or negative, about her as a person or as an internet personality? 3, have you heard of Daystar Peterson, professionally known as Tory Lanez, before today? If so, do you have any opinions, positive or negative, about him as a person or as an entertainer? Are you aware of the criminal trial where Tory Lanez was convicted of shooting Megan Thee Stallion? If so, do you have any opinions, positive or negative, about the outcome of that case? And this is going to be, I guess, presented in the selection period of trying to get the jury. And these are proposed. These have not been moved forward by the judge. 5, have you read or seen any articles, stories, or social media posts about this lawsuit? 6, could you be impartial in your decision making in a case involving a celebrity plaintiff, either for or against them? Have you ever been involved in a lawsuit involving claims of defamation, infliction of emotional distress, or promotion of an altered sexual depiction, either as a party or as a witness? If so, please describe what happened and how the situation was resolved. Have you ever made a complaint regarding someone saying something untrue or false about you? If so, please describe what happened and how the situation was resolved. From which source or sources do you get your news, including social media platforms? Okay, so these are the questions that Megan is proposing be accepted by the judge to be submitted to potential jurors. Also in the docket submitted today is defendant Milagro's motion for continuance of trial. This is what I talked about earlier in the video. Comes now, the defendant Milagro Elizabeth Cooper, by and through undersigned counsel, and files this unopposed motion to continue the upcoming trial during the trial period of November 17th to November 28th, 2025, and in support thereof states the following. This case is currently scheduled for a trial to commence on November 17th, 2025. The defense requests the trial commence on November 18th due to conflicts with undersigned counsel's schedule. So she's claiming there's some sort of scheduling issue with her legal team and they need an extra day to get started. Undersigned counsel has a sentencing hearing in the Northern District of Florida on November 17th that has already been continued once. Okay, so they've already pushed back this sentencing hearing once before. This date has been standing firm for quite some time, by the way, and we're a week away, and now she's trying to move the date. Undersigned counsel, in good faith and without unnecessary delay, requests that this trial be adjourned until November 18th, 2025. Undersigned has attempted to confer with plaintiff's counsel and has not received a response. So Megan's team ain't even said shit. Conclusion. Wherefore, Ms. Cooper respectfully requests that this court grant this motion for continuance of the upcoming trial. Okay, so there's that. And almost immediately, the docket says, paperless order denying 179 motion to continue for the reasons stated in open court. Signed by Chief Judge Cecilia M. Altanega. So her motion to continue was pretty much immediately declined by the judge. No. Kendrick, no. You know what I'm saying? Like a straight up Kendrick, no.
No, nigga. No. 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 Nigga. No.
Oh man, you can't write this shit up, man. Hey, but you can't fault somebody for trying. All you can do is ask. But damn. Now, moving into the next part of the show, we've got this clip here that's been shared. This went out a couple days ago. They say Mace and Mace, but clearly that's Cameron and Mace. Discuss Klay Thompson getting benched by the Dallas Mavericks, with people trying to blame Megan Thee Stallion. They talk about how when an athlete gets with certain women, it can help you or pull you down, okay? And Mace was making the case that he feels like Megan might not be the woman to uplift Klay Thompson in the way that he needs, or something to that effect.
Yeah, you gotta pay attention to this. Cause
Yeah.
it's some people that guys flourish with. It's some guys that they get this girl in their life and their career just take off. It doesn't matter if it's music. Like I think about a young lady I was with when I was writing all those smash hits. That was two girls that made all those records. And then I got with another girl and I couldn't get the same storyline. And the same thing is true with some of these ball players. You see them balling out, they go with this other girl, and it's like all downhill. I can name probably like 8 basketball players. You'll be like, word, word, word. Like, and then you get with some girls and you just be winning. I think this is some truth to that.
Well, see, this is the problem as well, right? And I think Mace is correct, 100% correct. But let's flip the other side of the coin. You got a girl that you with and you're winning, not just winning, you're flourishing, you're one of the best players in
Yeah.
the world, everything, you know, fucking win championships, medals, all type of shit. And then she wants to go on podcasts and talk about she's not happy with her role in life. Talking about nigga, now
No comment.
he's winning too much. I'm tired of the gold
Yeah.
medals. I'm tired of league MVPs. I'm tired of the finals championships coming to my house. I'm tired of hearing about he the best shooter in the world. Do you keep her around? Because you be like, long as this bitch around, pardon me, I won't call nobody wife a bitch, pardon that. As long as this female around, I'm winning. Maybe when I retire, I'll get rid of her. But right now, she's helping me win. When is it all gonna match up? When is everything?
All right, so the two sides of the spectrum that they have going here, both is loads of bullshit. But on one hand, you got Mace, right? So Mace is trying to make the case that you could be in a good spot, you could be winning, and I don't know who Klay Thompson was with when Golden State Warriors were winning all their championships. But you could be with somebody and you're winning, and then you turn around and get with somebody else, and now you can't seem to get your game right. That's what he's implying. Like Klay Thompson got with Megan, and all of a sudden his head ain't in the game no more, right? He done forgot how to play. He just can't buy a win. That's Mace's perspective. And then on the other hand, you have Cam, who says on the opposite end, you could be winning all you want, coming and getting all these championships like a Steph Curry, but then he has a wife at home who recently came out on a podcast and talked about how she never really wanted to be married. And, she kind of voiced some of, not that she didn't want to be married to him, but more so that she had to learn how to focus on herself and try to balance the things that she wants out of life. Because since he's taken off in the NBA, she had to take a back seat towards the other things that she wanted to accomplish in life, right? And the reason why I say both sides are filled with loads of bullshit is because if you actually listen to Aisha in her interview contextually, not just from the headlines, she never said she didn't want to be with Steph Curry. She never said that she wanted to divorce his ass. She never said any of those things. She just carries a load of being this mother to multiple, 3, 4 kids now? While Steph goes off and focuses on basketball. His main objective is helping the team win. And then during the summer, he gets to be a dad. But still during the summer, he's still focused on staying in shape, staying game ready, so that he could come back and help the team win when it's time. So, and I think that's something that most NBA wives encounter. Maybe they don't all talk about it, but that comes with the territory. And some people, perhaps they didn't have a lot of ambition or goals. I'm not going to say everyone, but maybe some of them didn't. And being an NBA wife is all they aspire to be. But I think many of them have to find outlets. They have to find businesses. They have to find things to get involved with. Real estate. Who the fuck knows? I know Aisha was doing a cooking show. I know she's gotten into other things. She's gotten into, trying to be philanthropic in the Bay Area. Like she got other shit going on, but she needed to find other outlets to feed her as a human being outside of being Steph Curry's wife. That's the conversation. But a lot of people took a 30-second, 40-second clip and made their own narrative. And of course, she doesn't do herself any favors because, she came out years ago talking about how she still desired to be or wanted to be desired when she goes out. Right. So it was kind of like she wanted to still appear sexy to the male gaze outside of her husband, which I thought was strange. I'm not going to lie. Everybody ain't perfect. But I still feel like the logic here is just like nigga babble. I ain't going to lie. And Mace, on the other hand, like Klay Thompson ain't played but about what? 2 weeks of official basketball in the season. Like, we not gonna get a nigga till December to get his shit together before we try to say it's Megan's fault. Like, and this is what I want to get into is let's look at Klay's performance for the last few years, because it ain't been all that great. He's coming off of fucking ACL, MCL, all type of shit. His athletic peak is over with. The nigga ain't never had a crossover a day in his motherfucking NBA career, but all of a sudden y'all expect him to be somebody different. All right. So we're going to go to the bottom here. So this here that I'm highlighting, 17.9, whatever the fuck. Y'all see it. 23-24. That was his last somewhat decent season. He averaged 17.9 points a game. He played about 29, we'll round it up to 30 minutes a game in Golden State. That was his last year with the Warriors. And they let him go. Didn't pay him. They let him go. All right? They knew he was not at his peak anymore. He's coming off 2 severe injuries, trying to recover. He had a couple decent seasons. Couldn't really play full seasons, but he came back and tried to put it on the board, man. So then he goes to Dallas last season, 24-25. He played 72 games last year. He averaged 14 points, all right, which is the lowest since his rookie season. Okay? That's last year, before Megan Thee Stallion. He starts this year. He's played 9 games so far. Literally, like I said, like 2 weeks of NBA basketball. He started 7 games. He plays 20 minutes a game, which is not all that. That's the lowest amount of minutes he's received in his entire career. He's averaging 7.6 points a game. So and wow, that's Megan's fault. But if you look at the previous season, Klay was not all that impressive. His free throw percentage was still high. His 3-point percentage was at 39%. And he had a rough time shooting threes. There was times last season where people literally was like, hey, man, it's time to hang it up, dog. And now people are trying to say the same. Again, this is a man coming off 2 major leg injuries, the very things that carry you in basketball. He is an elder statesman. He's 35 years old. He's on his 14th season. What more do you want from me? Okay? And again, if he don't got his shit together by All-Star break and it's still looking the same, maybe you can make that claim. I'm not saying it's out of the realms, but I think it's dumb at the same time. Because he's a professional athlete, whether he's dating Megan Thee Stallion or if he's dating fucking Megan the McDonald's worker. Either way it goes, he got to be ready for game time. Whatever he does off the court ain't got shit to do with nothing, unless he's Ja Morant, which he ain't. So, I don't like that shit. And I don't like the narrative that people are trying to paint. It's like every few business days, they find another angle to try to make Megan look like something she ain't. I don't appreciate that shit. But far as everything I can see, the nigga look happy. Off the court, that nigga look happy. They on the P-Jet feeding each other. Goddamn, they in the gym. She cooking. She had that nigga eating fish and spaghetti for the first time in his life. Like, he's fucking enjoying it. His family loves her. Like, the nigga's on his last leg. Let that man enjoy he need to be on a motherfucking retirement tour. I ain't gonna lie. But let that man enjoy his time, man. Let her enjoy her time with him. And I wish them more days and more fruitfulness, all right? Let me know what y'all think down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel. Become an insider. I will catch y'all on the next one, man. Peace. Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'm never politicking, the drama be piling on. Father and great son acknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5 sit bank accounts, every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that I read for filth. The sympathy calls, consulting for the stacks I built.